Hi viewers, this is Daljinder Kaur, Assistant Professor at CTU University. Today I am going to discuss with you a new topic, introduction of statute and classification of statute. Prior that we will discuss learning object of this topic to understand the meaning of interpretation, to understand the meaning of statute, to understand the role of legislation and judiciary, to understand the need of interpretation and understand the different types of interpretation. Introduction to interpretation of statute. Meaning of interpretation of statute. The term has been derived from the Latin word that is known as interpretare, which means to explain, expound and understand or translate the true sense of the meaning in which there is a confliction. Basically, interpretation is a process which is given by the judiciary to understand what is the exact meaning of the word in which there is a confliction, there is a problem. So next is meaning of statute. Statute is a written law which is given by the legislation after enactment with the particular subject matter of the statute. There are different type of statutes in the Indian country. Next is definition. Various definition has been given by the jurists Salmon and Blackstone. According to the Blackstone, the most fair and rational method for interpreting a statute is by exploring the intention of the legislature through the text and the subject matter, the effect and consequences, or the spirit and the reason of law. Now, what are the object of interpretation? First one is to discover the meaning. Discover the meaning means the confliction which is arised in the statute with the particular subject matter. The judiciary will interpret that word in a proper manner, in a true sense, so that a layman can understand the meaning of the statute, that what is the subject matter of the statute and what is exactly the word is saying in the statute. This is the duty of the judiciary, to interpret, to explain and give the clear meaning in a natural sense. But when there is a confliction in the statute. Second is to discover the intention of the author. Whenever the law is enacted by the legislation, always the law is made by them is without any ambiguity. There is no any kind of unclearness and vagueness. But the issues is arises before the judiciary. Then judiciary are supposed to explain that provision according to the subject matter with the true sense, with the clear meaning, so that a layman can understand that provision, that there is a confliction and we are getting confused with the provision. Third is intention of law. Whenever the law is enacted with a particular subject matter, what is the law and what is the reason behind it to make the law, that thing should be kept in mind by the judiciary, so that they can give the proper and natural meaning of the statute. This is the basic rule of the interpretation, that judiciary will seek that the subject matter should be according to the meaning of the word should be according to the subject matter. Next is basic types of interpretation. There are two types of interpretation. First is legal interpretation. Second is doctrine interpretation. Legal interpretation further is divided into two parts, authentic and usual. The meaning of authentic interpretation is, it is come from with the section we have to be with in the word, that for example the written law words has been given under the provisions. Judiciary will have to strict upon the provisions, so that they cannot go beyond the true sense of the legislation. Second type of legal interpretation is usual. It comes from either from the decided case or from the custom society. That means when judiciary is unable to explain the provision from the written words in the statute, then judiciary can go for the earlier decided case and the custom of the society to explain the provision. The next type of interpretation is interpretation. The doctrinal interpretation is further of two types: grammatical interpretation and logical interpretation. Grammatic interpretation, as per the plain English grammar, there are two words and or. The meaning of and is it joined the two different statement, and or joined the two different statement, but one statement is given the another meaning and other statement is giving the another meaning. Next is logical interpretation. When the court goes beyond the word to the true intention of the statute, that means it is used by the legislation at that time when judiciary has to go beyond the beyond the nature of the statute, beyond the legislation's word of the statute. Although the language is used by the legislation is sometimes hard, which is not understandable by the layman, so that therefore there is a judiciary who is interpret the statute according to the legislation sense. Now, what are the main function of the law? First one is to make the law. That is the main function of the legislation, who are responsible to make the law when they are getting a dispute between the parties and between the society. To implement the law, whenever the law is enacted by the legislation, executive's powers are bound to implement that law in the society so that the peace and order can be maintained by the executive officer. For example, IAS and SDM's officers are there who are responsible to implement the law which is enacted by the legislation. Third is to settle the dispute. Judiciary is there who are responsible to interpret the law and to settle out the dispute which arises between the parties and explain the statute according to the subject matter. Now, the next is role of judiciary for interpretation. This is the main role of the judiciary to interpret the law. Therefore, judiciary is known as interpreter. So, first one is determine the ambiguity. The meaning of ambiguity is when there is a problem in the word of the statute to understand the meaning of the subject matter, or we can say that if the judiciary is getting that the people are not able to understand this provision in proper language, then the judiciary are responsible to give the proper explanation of that words with the true sense that this word of the provision is saying that. For example, we can take example over here, the constitutional law, the article 25 of constitution, which is talking about the freedom of religion, right? So although legislation is giving a right to profess their religion according to their manner, but it is bar the people that professing of the religion, it should not be the disturbance, should not give the disturbance to the others people. Second is determining the intention of the legislation to make the law. It is very important of the judiciary, or we can say that the another role of the judiciary, whenever they are going to explain the provisions, they have to keep this thing in their mind, that they should keep this thing in their mind, that intention of the legislation. That means when the law was enacted by the legislation, what was the intention and what was the reason behind to make the law. Third is give the true sense to the conflicted word. The word which is in confliction, this is the role of the judiciary, that they have to give the proper meaning of the word which is in confliction. We cannot say that there are confliction between two words and only we are giving the proper meaning of only one word. No, judiciary has to give the both words explanation in proper manner. Second is, while interpreting, judiciary will not go beyond the intention of the legislation. This is the another responsible of the, or this is another role of the judiciary, that they cannot go beyond the intention of the legislation. They cannot interpret the law beyond the language of the provision. Last is resolving the ambiguity by applying the suitable methods. These are the methods which are used by the judiciaries to explain the provisions. There are different rules which is applicable by the judiciary to explain the provisions, that where is the confliction or what kind of confliction is there. If the judiciary is not getting any kind of confliction and the provision is giving the plain meaning, simple meaning, then judiciary will not apply any kind of rule to interpret the law, and they will say just that this provision is very simple and giving the very clear meaning, so there is no need to interpret that law. But if there is any kind of a confliction, then judiciary will applicable rules to explain that provision. For example, there are number of rules are in the interpretation to interpret the provision. For example, literal rule, grammatical rule, mischief rule, golden rule, and further secondary rules are there also. The next is need of interpretation of statute, that why there is a need to interpret the law. First is the statute's use of ambiguous language. When the statute is getting ambiguous language and uncertainty in the word, one word or more than two words, then judiciary will interpret the law with the proper meaning, and it might not be clear with the interpretation meaning applies. Second is complexity of the statute. If the people are getting the complexity in the statute and not getting the exact meaning of the statute, that what is exactly the provision is saying, that then we need to interpret the law according to the provision. Third is when a specific area is not covered by the law. We can take an example over here, e-justem generous rule, which is applicable on that provision when there are specific words are given and the general rules are given, and the people are getting confused in this general word and the specific word, that how we are supposed to understand this provision. Then judiciary will applicable this rule over that provision when there is a confliction in the specific word and the general word. Specific words are those words which are given under the law with the proper category, and the general rule are given in the provision in the word like extra, others, otherwise. These kinds of words will be in the provision, and judiciary will provide that word according to the specific rule. Last is incomplete rule. When there are few implicit law, norms and privileges that are not explicitly stated in the statute, and when these are not clearly established in the statute, it clear uncertainty. When the statute is not enacted by the legislation in proper way, and that time judiciary will interpret the provision according to that thing. Judicial interpretation by the Indian court. In the case of Golaknath case 1961, it is alleged that Parliament lacks the authority to amend the fundamental rights. It was also stated that Article 368 only gives Parliament the right to initiate the constitution amendment process. Fundamental rights now have a transcendental status as a result of this ruling. Now the next is classification of statute. Codifying statutory law can be categorized as follows. First one is codifying statute. The purpose of this kind of statute is to give as authoritative statement of the rule of the law on a particular subject, which is customary law. For example, Hindu Marriage Act 1955, the Hindu Succession Act 1956. That means prior that these kinds of acts are not there. Only the people were supposed to understand the things according to the customary law. Then the legislation had made their mind that every provision should have the particular status so that people can follow the rules and regulations decision in fair manner, and they cannot act any wrongful act. Second is consolidate statute. Here we can take an example over here, Indian Penal Code or Code of Criminal Procedure. These are the consolidated statute which is enacted by the legislature. Remedial statute. Remedial statute statutes are those statutes which are enacted by the legislation to protect the rights, protect the one's rights, so that the remedial can be provided to the society. The purpose of these kinds of statute is to promote the general welfare for bringing social reforms through the system. These statutes have liberal interpretation and thus not interpreted through the strict means. That means there are two ways in which the judiciary can interpret the law, in the liberal manner and in the strict manner. Sometimes judiciary has to be in the liberal manner so that the proper meaning come out and the people can get that subject matter. The next is the strict construction. There are a few of the acts are there, or few of the statutes are there in which judiciary has to be with strict over there, have to strict over there so that they can explain the provision according to that, because each and every law is made by the legislation only and only to implement the law over the society. Enabling statute. The purpose of this statute is to enlarge a particular common law. For example, Land Acquisition Act enables the government to acquire the public property for the purpose of the public, which is otherwise not permissible. Next is penal statute. The offences of various type of offences are provided through these statute, and these provisions have to be imposed strictly. IPC. I have already discussed with you the judiciary will interpret the provision in the liberal manner and the strict manner. So, in a strict manner, judiciary will implement the provision or will explain the provision strictly in IPC, and another is taxing statute, which is also interpreted strictly. That means the judiciary has to strict upon the provisions. They cannot go beyond the provision and they cannot give any kind of explanation beyond the provision. Taxing statute is form of revenue which is to pay the government. A taxing statute levies tax on all such transactions. There can be income tax, wealth tax, sales tax, gift tax, etc. Amending statute. Amending statute are those statutes which is amended by the legislation. Amendment is done only when there is a confliction. If there is a confliction or when there is no need to that law in future, then the judiciary can repeal or amend that law. For example, Code of Criminal Procedure 1973 amended the Code 1898. Repealing statute. A repealing statute is one which is terminated as earlier statute and may be done in the express or explicit language for the statute. For example, Competition Act 2002 repealed MRTP Act. So here legislation had made a proper law related to the competition, so that each and every provision has been provided under this law. Conclusion. Now, as we know that judiciary is empowered with the interpretation of the language, in which the problem is arising, in which the ambiguity is there, so that judiciary can interpret the provision according to the rules and the regulation, and they cannot go beyond the true sense of the meaning. Thank you.